These are not in contradistinction. These are not at war with each other. A stable government, a sovereign people, and human rights are not in conflict with each other. They are in harmony. It is the work of the court to interpret in order to create that harmony. When the court is invited to interpret the Constitution so as to create an absurdity, it must refuse to do so. This afternoon, you are being invited to interpret the Constitution to create an absurdity. Why is it an absurdity? The Deputy Chief Justice of the Republic of Kenya can swear in the President of the Republic of Kenya into office. What a huge power. What a huge authority. The Deputy Chief Justice of the Republic of Kenya can empanel a panel of judges, can appoint a tribunal to remove the president from office. What a huge responsibility. What huge authority. But wait a minute. The Deputy Chief Justice cannot assign duties to judges. Pray, my lords. What then does the Deputy Chief Justice deputize? What does she deputize? In many jurisdictions, like those referred to by the distinguished counsel on the other side, in many jurisdictions, including the United States, there is no office of Deputy Chief Justice. In the Supreme Court of the United States, there is the Chief Justice and Associate Justices. In Kenya, the drafters of our Constitution, and if I may say so myself with a bit of humility, I was one of the draftsmen. Knowing that in other countries there was no office of Deputy Chief Justice, decided in Kenya there shall be an office of Chief Justice to deputize the Chief Justice. In doing what? I'll be very brief. That is to be found in the Constitution itself and in the statute, and I think I will leave my learned friend, Mr. Ngobo, to deal with that. But let me, in the 2 minutes I've been granted by this gracious lady, make 1 point, 2 points. Beneficiaries of ex parte orders stand before this court and say, only they are entitled to ex parte orders. They are here to complain that they went before Judge Mongo, they went before Judge Mwita, they got ex parte orders with finality, and that was okay. But when the Attorney General went ex parte, and all her prayers were refused, except the prayer to send the matter to the Chief Justice, she was wrong. How is that possible? My lords, I want you to remember, because it is in your file, the transmission from Kirigoya is in the portal. Unless my learned friends are saying they have never seen the portal itself. Yeah? The registrar in Kirinyaga, Honorable Wanyama, writes a letter, yes, saying, good evening, kindly find attached the document for your attention. It has a time to the Chief Justice. It is on the 18th, and it is 15:45. It is 15:45. It is 3:45 in the afternoon. So when council repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants. It is not true. It is not true. The registrar sends the order at 3:45 in the afternoon. I stop there so that my learned friend may continue.
Thank you. My lords, I will take it up from there, and I will dive right into the constitutional questions. The application before you for challenging the empanelment of this bench addresses itself, my lords, to the powers of the Chief Justice under Articles 161, 2A and B, that establishes the office of the Chief Justice as head of the judiciary and of the Deputy Chief Justice as the deputy head of the judiciary. And conversely, my lords, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and be the Vice President of the Supreme Court. My lords and your ladyship, it is now beyond peradventure, and again quoting from the CTS, that while council submitted that there may be instances of delegation, they ignored, my lords and your ladyship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Cap 185B of the laws of Kenya. The Judicial Service Act expressly provides, my lords, that the Chief Justice can deputize, or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. My lords, the CTS and my learned friend Professor Gidu Mugai has referred to this. There are only two professors senior counsels here, so he must be correct. My lord, in the CTS, it is clear that the Chief Justice communicated to the Deputy Chief Justice that should be away to Geneva, Switzerland, and Milan, Italy, between the 12th October 2024 and 24th October 2024. That is in the bundle.
It's in the bundle.
It's in the bundle. It's on record. It's on record. Senior counsel and my pupil master Paul Mwete. It is in the bundle.
Keep your voice calm. There's no need to shout. I was asking the court whether this material is part of the contract.
It is.
It is on record.
It is. Remember, you taught me to submit clearly. You taught me to submit clearly, and I am polite.
You were actually his pupil.
Yes, I was his pupil. Yeah. My lords and your ladyships, it is therefore
that the rest of the Sudan application did not file any reply affidavit. Through which this material for
my lord, it is part of the record. The record
the material which is in the court portal is part of the court record.
Yes, my lord.
Yes.
If it is not on the portal, it's okay. If the material is in court portal, it's part of the court record.
Mr. Ndegwa, just give us an opportunity.
May we know, because we access the portal through particular case numbers, in which case file is this material available that has not been engaged?
My lord, it is not in my place to start educating or demonstrate to my learned friends what file to look for. Because this is in the portal, I would have had no other way of accessing
Professor, can you just give us a reference
Yes, I had.
for purposes of clarity?
Yes, my lord. 05. We have 3 cases that are consolidated. We have accessed the portal in E015 of 2024, a transmission from Claire Wanyama, and E014 as consolidated. We have this material and they're aware of it. We have even gone further, my lord, and served or passed on the communication to my land. It is in the public domain, my lord. We could not have secured this communication from anywhere else.
Do you mean to say that what you are holding is on file on CTS?
It is, yes. It is in the, what I have here is a copy from the CTS with a reference from the Chief Justice's office. We only accessed it from the portal.
That's not straightforward. It's an internal memo we've just been given. My colleagues are saying it's on the portal. If we knew the case number which it was, we would have verified it. The other option would have been for my colleagues to reacting a particular application this afternoon. Have they found an affidavit that this document? Truth of the matter is that the documents in the CTS have a timestamp, as my lady points out. The document we are having here does not have senior timestamp. We're just saying, show us where it is, then we authenticate, then we make progress. It doesn't make sense to demean the rest of us when you are asked to authenticate. You do precisely that, you authenticate.
My lord, I can confirm that it is even in the physical file. This document in the physical file. So that my learned friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a process for the my lord, if I may, they're eating into my time, they will have time to respond. Yes, the judicial report was, I can proceed if...
We want to know in which case file in the portal. Is this internal memo? First, around the internal memos are in the portal, but more importantly, in which case file is this internal memo, so that we can authenticate. That's simple. My colleagues have said this in the portal. Because I think furnish us with the particulars.
Yes, we have indicated, my lord, that it is in the physical file. My lord, Mr. Nyamodi will specifically address him to that so that I can proceed, my lord. My lord.
Please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time to make a response.
My lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management, my lords, and the need for expeditious disposal of the application before you cannot be overstated. My lords and your lordships, time and again, my learned friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Of course, no doubt, my lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms, my lord. My lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my learned friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My lord, what we are dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my learned friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, Mr. Kamino, just give me time. All the orders obtained under the subject of this proceeding were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my Lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. And the next phase, my Lord, would be dealing with the question of the next step. My Lords and your Ladyship, it is clear that my learned friends do not want to proceed to that phase. And that is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceedings, my Lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer in this. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Article 161, 163, 52A of the Judicial Act. We opine, my Lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you, my Lord.
My Lord, my Lady, as a follow-on to the submission by my two learned senior colleagues,